Um, Sorry, Your Honor, my computer hit rejoin at the very last minute. I apologize. There we go.
No
There.
problem. I see you both. Welcome, gentlemen. And I don't know if you were involved when the court opened at the very beginning this morning, but let me just take a minute to kind of go over it. Mr. Wash and Mr. Joanka, because we are appearing virtually here, it's almost like we're in a real courtroom. Each side will be allotted 20 minutes to make their argument. And Mr. Washington, because you're the appellant, you could reserve up to 5 minutes for rebuttal. And I do have a little timer here that I keep track of people's time. So each side is giving 20 minutes to make their argument. I'm just going to ask one request, Mr. Joanna, to have you mute your microphone. So whenever Mr. Washington is ready, we are ready to hear your argument. And just to let you know, Mr. Washington, we have your brief. We reviewed all the record here. So whenever you're ready, sir, the court is ready to proceed, sir.
May it please the court. My name is Michael Washington, and I'm requesting 5 minutes of time for rebuttal.
Very good.
And I'm gonna rely on my brief for any issues or arguments that I might not cover.
Very good.
This case involved a trip and fall accident. It was dark. There was no lighting. There was no barricades, no pylons, or anything around the construction around the site. I did not see the 2x4. Before I get into those types of things, let me give you a little background information about myself. I worked for over 30 years in law enforcement. I worked as I was employed as a police officer, a probation officer, or I worked in corrections. In my last job, I was employed at the United States District Court in the probation department. I was what you call a sentencing guideline specialist. I completed pre-sentence investigation on high-profile case, complex fraud cases, and large-scale drug cases. I spent thousands of hours in court. I witnessed just a lot of time in court. And during my tenure at the probation office, I never recalled an occasion when a prosecutor or defense attorney made a statement that they should have known or knew were fraudulent. I never witnessed a witness take the stands and make fraudulent statement, and I never witnessed an attorney abandon their client during trial. And all those things happen at court. And I'm gonna talk about it later. It's a sidebar conversation that and it's in my brief, sidebar conversation that the court had concerning Florida Department of Transportation only witness. The court indicated, and the attorneys indicated that Mr. Curley, which is the only witness, had no knowledge about the accidents or until the deposition. And I'll explain later why I made that point. The court also indicated in that deposition that they want to take a curative action concerning a question Mr. Joanna asked me about a previous auto accident. The court made no such curative action or no such correction. So that's a fundamental error made by the court. But I filed this appeal based on important questions of law. There was unobjected to closing argument, improper closing argument, comment that would be considered fundamental error resulting in actual prejudice to me, abandonment of the attorney-client relationship of the trial, the appearance of impropriety between the counsel to throw my case. I'm just going to talk about a few of the improper statements during closing argument that Mr. Joanna made. Mr. Joanna stated to the jury, did you see Mr. Washington? Have you seen him squirm? Have you seen him grab his back? Have you seen him look uncomfortable when he took the witness stand? Did he stutter? Did he go indicating? Did he look uncomfortable at all during the last 2 days? In essence, what Mr. Joanna is asking the jury to do is ignore the evidence. Make your own decision by looking at Mr. Washington, and maybe you can determine whether he hurt his back or not. This comment was inflammatory, highly prejudicial, and unneeded to be cured. The trial court did not unring that bell with any warning instructions for the jury to disregard it. That statement alone was grounds for a mistrial. Mr. Dwana made other statements during this closing argument. Mr. Dwana received a fraudulent deficiency letter from Mr. Curley. And in that deficiency letter, I think that's the defendant exhibit 2. In that deficiency letter, the wrong contract is listed and the location of the accidents where I fell is nowhere near. Like one of the locations is Puritan Avenue. Puritan Avenue is 2 miles south of the work site that DOC, Department of Transportation, was doing. Another location in the deficiency letter was a half a mile. And the disturbing thing about this deficiency letter, it was written by Mr. Thomas Curley, and in his closing argument, Mr. Dwana stated, Mr. Curley testified, and Mr. Curley, during the deposition, indicated he had never been to the construction site. He's as an administrator, they didn't go to the construction site. In his closing argument, Mr. Curley later testified at trial that he went there 1,000 times. Mr. Dwana said 365 days, bouncing around 3 or 4 times a day. Mr. Dwana knew that to be fraudulent. This job site, this job probably took about 2 days. So he said those things in order to get a favorable ruling from the jury. I'm gonna read this thing. In this closing argument, Mr. Dwana then willfully, intentionally used Mr. Curley knowingly impeachable, unobjected to, unimpeached testimony about visits to the site to not only put on false evidence, but also incite or provoke the jury to believe that there were absolutely no way or any possible neglect on the part of the Florida Department of Transportation that was a legal cause of injury to Mr. Watson because of the 1,000 times. Mr. Curley alleged that site. Well, you heard the project manager testify he was on site personally 1,000 times. That's a lot. That's beyond reasonable for me. For the actual landowner to come check on the work, not 100 times, 1,000 times. That's a lot. That means he's there every day, more than once a day, 365 days a year. That means he's there 2 or 3, 4 or 5 times. What I want the court to know is this. Mr. Curley never stated that, not once, and that he himself had been to the site. In fact, Mr. Curley stated as project manager, we're not in the field exactly, especially now with cell phone. So the fact I never knew of this incident, so no, we get pictures. At trial, Mr. Curley changed his testimony and testified in contradiction to his prior deposition stating that he visited the site in question thousands of times. Critically important is that Mr. Curley himself, when asked at trial if he was on site on a daily basis, contradicted his and Mr. Dwana's later closing argument by stating no. So stating no. Applying the Murphy rules to these facts, Mr. Dwana's statement was improper. Mr. Dwana was not at liberty to use Mr. Curley's witness testimony in a manner calculated to produce false testimony or false evidence. Mr. Dwana knew that the statement was false, but exploited it in a way in his closing argument with the sole purpose of obtaining a favorable verdict. So Mr. Dwana knew, and my former attorney knew that because they took the deposition that Mr. Curley had never been to the work site. My attorney didn't object. That's why this is improper. Mr. Dwana knew the statement was fraudulent. I think we briefly talked about the deficiency letter, that the locations were wrong on the deficiency letter and that the wrong contractor was listed. The second district has considered the importance of these legal questions before. In Baggett versus David, the plaintiff sought recovery for injury from an auto accident and prevailed. The defendant asserted that Plaintiff counsel committed numerous errors during the closing argument and trial. In Baggett, it was determined that the trial court had a duty to check improper remarks whether or not acts to do so. Some improper remarks can be corrected. The cases Baggett, unlike Baggett, my case, the judge didn't give any curative instructions or give any instructions to correct the errors or improper remarks by opposing counsel. The comment was such a nature, sinister in nature, to rise to the level of fundamental error. Also, the trial court did not conduct a proper review of the motion for a new trial. I talked about the sidebar conversation earlier. All the parties involved except me, because I got the transcript after the trial. All the parties knew that Mr. Curley, who testified as the corporate representative, didn't know anything about the incident. Mr. Curley testified about a lot of things that he had no knowledge about. He made comments or gave his opinion, but my attorney didn't object to him giving his opinion, or stated that he stated the wrong accident location. One occasion, Mr. Juana asked Mr. Curley about whether there was a sewage drainage pipe installed at 113, and Mr. Curley said no, but the concrete drainage pipe is 100 yards south of 113th Avenue. The day I felt DOT were installing stormwater drainage pipe to get the water off the road. In the factual errors, the defendant intentionally put on false evidence, gave the wrong location of the accident, presented a Google map evidence. I think that's defendant exhibit 1. This exhibit and defendant exhibit 1 is Google Earth thing, showing the construction site that was in April of 2012. My accident happened in October 2nd, 2012. So the Google Earth photo that they submitted, even though Mr. Juana didn't ask me any question about it, should not have been allowed in the trial, but the jury saw it. And the reason for showing the Google Earth thing is to give the juror an impression of how construction site looked. Like I said at the beginning, when I was jogging down 56th Street South, when I came up to 113, there were no barriers, there were no barricades, there were no lights, there was nothing to indicate that construction was going on at that location. So I felt it was safe to continue. When I jogged approximately 80 yards, I fell over a 2x4, and like I indicated in my brief, the cement barriers were supporting the 2x4s to make it easy for them to install it. Contradict the factual record that I could walk out of my front door and see the accident site, and that I drove by the site on the way to work. It's another misstatement. And these are things that went on in this trial. Mr. Juana told the jury that I could walk out of my house and see the accident site. I live in Temple Terrace on 113th Avenue. On 113th Avenue. 113th Avenue on the residential side, it deads in at 62nd Avenue. So there's no way possible. On the other side, the business side, it's a short 20, 30-yard road that also deads in. So Mr. Juana should have known that if he's gonna state it in court as a fact to the jury, that I could walk out my house and see the accident site. It was false. And when I asked my attorney about it, he said the same thing. So I got the impression that neither attorneys took the time to visit the accident site. And Mr. Juana, if he's gonna make that statement, he should have came by my house, and he would have noticed that was untrue. But presenting irrelevant, immaterial, voluminous, overly broad evidence may persuade the jury, knowing that the jury could not possibly read the thousands of pages. He submitted a manual to the jury, and he said this to say that it would be unreasonable. 1,000 pages, but he did not have a letter or anything indicating that the subcontractor signed that manual or read that manual. So you submit a 1,000-page manual. It was nothing presented or no evidence presented that the subcontractors ever received that manual. My attorney should have objected to it. It's voluminous and ain't no way possible that the juror could have read it during the deliberation. I'm respectfully asking that you grant me a new trial in part or on all of the issues that the weight of evidence in my favor. As in Baggett, I was prejudiced by unobjected to improper comments of opposing counsel, unlawful coordination to throw my case on by both attorneys. A proper review by the trial court will have granted my new trial. The now has resulted in manifested injustice. My only remedy is to be compensated for my injuries.
For that, Mr. Washington, your timing is perfect. If I start you right there, you'll have 5 minutes for rebuttal, sir. Very good. Excellent. I'm going to trouble you to please mute your microphone. And Mr. Joanna, I believe, is ready to proceed. And whenever you're, let me just kind of clear this time. All right, whenever you're ready, Mr. Joanna, the court is prepared to go.
Thank you, Your Honor. May it please the court, my name is Matthew Joanna and I represent the Florida Department of Transportation, who was the defendant at trial and is the appellee in this appellate proceeding. The first thing I want to reference is I cited the R.J. Reynolds versus tobacco case in my second footnote because the core of Mr. Washington's complaint, no matter what legal definition we give it, fundamental error, manifest weight, the common thread is an accusation that false evidence and false testimony and false argument and a false narrative was presented to a jury between myself and another lawyer who I have never had a case with before and didn't know, in order to throw the case of a man I didn't know to protect the government. It's just completely improper and outrageous, especially when it is not supported. Now getting to the facts or the merits of the case. This appeal can only be about one thing and one thing only, and that is fundamental error during closing argument. And the reason being is because all exhibits, all photographs were admitted by stipulation between the parties prior to trial starting, where there was no objection, no motion to strike, no request for a curative instruction, and no motion for mistrial. Those issues are forever waived. The one exception to that is fundamental error during closing argument. Likewise, not an issue in this appeal is anything that was done outside of closing argument for the reason just set forth. Also not at issue in the appeal was anything having to do at all with causation and damages. Reason being, the jury's verdict form came back and said one thing: is FDOT negligent? Answer: no. That being the case, the jury never considered anything in regard to causation or damages.
Well, I think that's a compound question, if I recall, unless you guys did a special verdict form. Doesn't it say, was there negligence that was a cause of damages?
Your Honor, the verdict form is in the record and I do not have it in front of me. So
I think that that's what it said, because that's what these all usually say, which I always leaves me scratching my head in these cases where causation is disputed, because you got a problem because you don't know if the jury found negligence or no causation. Right. Anyway, go ahead.
I will say that the verdict form is in the record and we probably used whatever standard form.
That's standard. It's a head scratcher to me, but it's standard.
Understood, Your Honor. The first issue in regard to there being no fundamental error, first and foremost would be the directed verdict issue. One of the things alleged is that there was pieces of wood across the sidewalk. FDOT disputed that. FDOP put on evidence that disputed that. And yet, during the case in chief of the plaintiff, no evidence was presented as to constructive knowledge or as to actual knowledge. Therefore, when moving for directed verdict that no prima facie case has been set forth, the court denied that directed verdict and let.
You didn't cross appeal. You haven't cross appealed that, right?
No, Your Honor. I'm actually very glad you brought that up because this was brought up in a previous motion with the court because there was a motion to strike my brief. And these cases were cited in that motion, but not the appellate brief because I did not have the chance to respond to a reply brief. But a cross appeal is actually prohibited. And the reason being is that the case law is that only if the final judgment is not wholly favorable to FDOT am I allowed to file a cross appeal. And that case is Credit Industries versus Remark Chemical, 67 Southern 2nd 540 at 541, Florida Supreme Court, 1953. Also, there are cases that specifically say that when I don't seek anything that, if the verdict is wholly in my favor, and I'm only asking for an affirmance on whatever ground, that it is not a cross appeal. And that's Breakstone versus Barron Surfside, 528 Southern 2nd, 437 at 439, 3rd DCA 1988. Also Webb General Contracting versus DPM Hydro Storage, 397 Southern 2nd, 1058 at 1059 and 60.
Well, okay, I'm familiar with all that, but I don't know how you can argue that we don't look at anything after your motion for directed verdict if that's not an issue in front of us.
I guess the only argument would be, Judge, is that if directed verdict had been granted, which is a ground that.
No, I know what your argument is, but I'm not with you on that one.
Let me move past it then, Judge.
Yes, I can't speak for my colleagues.
Obviously, you know what the argument is. The position's been made in the brief.
Right.
The next issue would be the actual even waiver of the fundamental error issue. The case law, including Murphy, Murphy states that relief may not be granted in a civil case based on improper but unobjected to closing argument unless such argument is first challenged, in the key words, and judicially evaluated in the trial court. The motion for new trial that was filed on Mr. Washington's behalf by his prior counsel does have the word fundamental error in it, and it does have the words manifest injustice in it. However, it doesn't cite Murphy. It doesn't go through any Murphy analysis. It doesn't list any of the elements of the Murphy test. So therefore, the appellant is essentially saying that the trial court committed fundamental error on issues that it was never asked to look at or resolve. And therefore, even with that, the improper argument of fundamental error has indeed been waived itself. If we get to the Murphy test itself, it requires improper, harmful, incurable argument that so damaged the fairness of the trial that the public perception of integrity of the court's system of justice would be affected if a true new trial were not made. When it comes to the
as I read the motion for new trial and the transcript of the hearing, I didn't really see that argument was made. Are you saying it was made?
No, Your Honor, that's one of my positions for waiver.
Okay.
If you argue fundamental error in closing argument, you must assert that, and you must assert the Murphy test, and you must allow the trial court to judicially evaluate what you are saying is fundamental error. And that was not done in this case, which is why the fundamental error argument is waived under Murphy.
Okay.
So essentially, he's asking the appellate court to make an analysis to say that the trial court committed error when the trial court was never even requested to make that analysis. The only thing in his motion for new trial, the words fundamental error are in there, and that's it. And as this court has held before, that mere use of words or legal terminology or throwing words up against the wall are not sufficient to support any judgment. In regard to the Murphy test, it's a real simple thing. The only thing the court needs to do is read the closing argument. If you read the closing argument from start to finish, it is not anywhere close to a Murphy test. One of the cases I read to get an analogy of what is.
But wait. I just want to,
Yes.
because you're confusing me.
Okay.
You keep saying there is no Murphy argument, but you keep talking about it.
Judge, I guess what I'm saying is on one point, the Murphy argument has been waived. It shouldn't be before the court to consider it.
Okay.
Alternative, if the court disagrees with that and the court does want to apply a Murphy test, I'm trying to explain why it fails the Murphy test.
Okay. All right.
Okay. So you are correct, Judge, that because it was not preserved, this Murphy analysis and fundamental error issue has been waived. Assuming the court disagrees with me and says, no, we think we should go through the evaluation, I would say that the Murphy test is not even close to being satisfied. If you read the entire closing statement or closing argument, it is a generic standard closing argument. There is nothing Murphy about it. One of the things that I looked for an analogy was I found a case from the 2nd District, which was Mercury Insurance Company versus Moretta, 957 Southern 2nd, 1242, and it's back from 2007. So I don't know if anyone on the panel has specific recollection of that.
My recollection of maybe I'm getting this confused with another case, but my recollection of the hearing on the motion for new trial was that the attorney for Mr. Washington, I think, argued he didn't really have a problem with what Mr. Washington's trial attorney had done. Is that right?
That is correct, and was
I
confusing.
mean, he didn't want to criticize his lack of objection. Is that, am I remembering that correctly?
You are, Judge. One of the grounds in his brief was what I consider to say ineffective assistance of counsel, which is not a defense in a civil case. Your remedy is a malpractice case. But that being said, you are correct, Judge, that Mr. Simpson, in arguing the motion for new trial, said that he did not have a problem with Mr. Boyd, which is a little inconsistent with the brief. But the case that I bring up before the court to give an illustration of the closing argument in this case to a closing argument, which was quite ridiculous, and this court held was still not meeting the Murphy standard, was the Mercury Insurance versus Moretta case. In that case, the 2nd District Court of Appeal painstakingly took many pages to demonstrate the closing argument that was given by another lawyer. And in all candidness, really kind of painted this lawyer as an absolute clown, as he might have been at trial, saying things of personal opinions and what his child may think of this.
I think the argument here isn't that it was improper comments as much as it was a failure of counsel to object to argument about what the testimony in the record was. Like there should have been objections to statements that weren't, facts and evidence, or that Mr. Washington believes were false statements by witnesses. Not
Judge,
so much, this isn't one of those outrageous comments type of arguments, is it?
I think he's arguing both. I guess he's the best person to answer that, but I agree with you that the crux of his
Well, you're the one talking about Mercury, so that's why I'm trying to understand the connection.
Okay. What I believe his argument to be is that the Murphy test is satisfied. And to that extent, I would say read the closing argument and the Murphy test is nowhere near satisfied. I do agree with you that the common thread seems to be a problem with his own lawyer, that my lawyer should have objected, that my lawyer was in cahoots with the FDOT, that my lawyer threw me under the bus.
Well, go ahead. Don't overstate. I would just caution you not to overstate that, please.
I'm sorry, Your Honor. It is in the record, but I will move on. So in that regard, his problem in the most basic form is my lawyer didn't object. I've cited some federal cases, including the 11th Circuit, which said it very well, that when your lawyer doesn't object, well, the Florida law says that when your lawyer doesn't object, it's waived. And the reason why it's waived, in one of the cases I cite in the brief, is because an appellate court is not going to second guess a decision of counsel on whether or not his failure to stand up and object was incompetence or strategy based on how he felt the trial was going at the time. The court's not going to enter Mr. Boyd's mind as to why he did not object. The only thing that matters for the court is that he did not object. And therefore, anything that is not fundamental error in closing argument under the law is waived. If that answers the court's question.
Yes.
With that, I would simply ask if the court has any questions about my brief or any questions in regard to the case.
Very good. Thank you, Mr. Juwan. I'm going to trouble you to please mute your microphone. And Mr. Washington, you actually have your entire rebuttal time of 5 minutes. Whenever you're ready, sir, the court is prepared for you.
May it please the court again. Mr. Juwan incorrectly stated my appeal. My appeal is based on improper, unobjected to closing arguments. Mr. Juwan didn't address the fact that he used Mr. Curley's fraudulent testimony in his closing argument. He said that Mr. Curley wasn't at 365 days, not 3 times a day, 4 times a day.
Well, now, wait, Mr. Washington, Mr. Washington.
Yes,
I
ma'am.
read Mr. Curley's testimony, and Mr. Curley did say that. That was something he testified to.
Yes, but in this,
So
what I'm saying to the
Mr.
court,
Juwana is allowed to comment on testimony that was given. It was your lawyer's job to decide whether or not that should be objected to.
yeah, no, I understand that.
And I know that you have a problem that your lawyer did not do that, or
I have a-
even did not cross-examine Mr. Curley about that when he testified to that. But the jury heard the deposition and the jury heard the testimony at trial. Is that right?
Even that, Your Honor, what I'm saying to you, at his deposition, and even in the sidebar conversation, everyone knew that Mr. Curley had never visited the site. He said,
But he testified, I've been out there thousands of times.
right. And he also testified.
The way I understood that, the context of that was he gets these dailies from their inspectors, and he goes out to make sure that the dailies are properly done. It's what I see, what's reflected in the daily. I mean, that's the way I understood the testimony.
What I'm saying is his conduct was fraudulent. Mr. Curley had never been to the site. That's what I'm saying. Mr. Curley's testimony was full of hearsay and full of opinions. And those things should have been objected to. Also, and like I said, another,
I understand that that's your position, that it should have been objected to.
okay.
But that's an error, if it's an error at all that was made by your lawyer and not by the trial court. And we can only review errors that the trial court made.
Another
So if
thing.
you could help me, if you could help translate what I understand what you're saying, but translate that into what the trial court did.
The trial
was a
court
legal error.
And I'm gonna move on. I'm just gonna say one thing. The trial court should have made a corrective action, curative action. The trial court was aware of the fact that Mr. Curley hadn't been to the site, but I'm gonna move on.
Okay.
The next comment is about swarming in MSC. He told the jury. He said to the jury, I'm gonna say it again. Have you seen him swarm? Have you seen him grab his back? Have you seen him look uncomfortable? When he took the stance, did he stutter? Did he indicate that he looked uncomfortable at all? This comment was highly inflammatory. It was prejudicial and unable to cure. The trial court took no action to unring, it could not unring that bell with warning instruction. The statement was grounds for a mistrial. He made those statements to the jury. He told the jury, ignore the evidence, ignore the doctor's testimony, ignore the medical record. You make your decisions on that. Mr. Dwana been ignoring the evidence, and I understand because this was a conspiracy between Mr. Dwana and Mr. Boyd. Mr. Dwana knew that Mr. Boyd was not going to object to anything, but I'm not going to go off that. He knew that going.
Well,
Going
now,
in-
Mr. Washington, I'm going to caution you too. Be careful what you're saying, please, because I don't think that's supported by the record anywhere.
That okay.
That may be your belief, but I'm not aware of anything in the record that supports that. So I just caution you not to be overstating things or talking about things that aren't in the record.
Okay, in the records, we know my attorney only filed one objection. And that one objection was about when Mr. Boyd was questioning me about one exhibit. And that exhibit shows the place where they were installing those concrete barriers. He objected because Mr. Dwana asked him, why didn't your attorney ask you about this? But I'm gonna go to my conclusion because it's in the record. Mr. Dwana, in my opinion, willfully and intentionally used Mr. Curley knowingly impeachable, unobjected to arguments.
And if I may, Mr. Washington, you'll need to wrap it up because you actually have reached your rebuttal time, sir. So if you just take a few seconds just to wrap it up, I'll give you that.
Okay, I'm respectfully asking that you grant me a new trial in part on all of the issues. The great weight of the evidence was in my favor and against F. As in Baggett, I was prejudiced by unobjected to improper comments of opposing counsel and unlawful coordination to throw my case by both attorneys. A proper review, the trial court would have granted my new trial. The denial has resulted in manifested injustice. My only remedy was to seek compensation in this matter. Thank you, Your Honor.
Very good. Thank you, Mr. Washington. Thank you, Mr. Joanna. And I think this concludes the court remote session of arguments. At this time, the